Just by merely calling a term sheet binding does not mean that the term sheet becomes binding. Similarly, just by calling it non-binding doesn't mean that it will actually be non-binding. Judicially and from a legal perspective, let's say if a term sheet is challenged ever in a court of law, anyone is always going to look at what is the intention that the parties had entered into while they were signing the term sheet. So the language that you use in the term sheet is important to understand, or will help somebody determine if such a term sheet can even be made enforceable in the first place or not. So you need to run through all the clauses and then see what is the intent between both the parties. Another very important factor is that for any contract to be accepted in a court of law, it needs to be stamped. Now, practically from a business perspective, where an investor has entered into a term sheet with a company and they have kept it non-binding, they're not going to really stamp it in a way because that's going to be an extra cost. And what if tomorrow in a situation you don't execute the transaction, then all of this amount that's gone to the stamp duty is going to be down the drain. So generally, any document that needs to be accepted in a court of law needs to be stamped, and that is something that you should consider, because if it is not stamped, I don't think so any court of law is even going to accept it as a document of evidence. And if that point of time, if you want to enforce a document which is not stamped against another person in a court of law, as and when it is produced, the court of law is always going to say that you can now stamp it, pay the penalty, and then only I can take it then legally. So generally, term sheets are not enforceable unless the parties have agreed otherwise. And there's a good enough reason for this, because the investor has still to conduct a due diligence on the company, and he does not want to be in a situation where he finds some issue in the due diligence process and he does not want to proceed with the transaction. So therefore, that is one of the main reasons why generally both the investors and the founders, along with the company, agree to keep the term sheet non-binding on either of them, so that if there is any issue at a future date, they can proceed to walk out of it comfortably without any issues being created between both the parties. So as I mentioned earlier, a term sheet is generally not binding between the parties, except that there are three clauses which are normally kept as binding in the document, and there is a good reason for it. So let's take up these three clauses. The first clause, and the most important clause from an investor's perspective, is the clause on exclusivity. What this clearly means is that the founder and the company, after signing the term sheet, cannot enter into discussions or negotiate new terms or seek funding from some other venture capitalist other than the person with whom they have signed a term sheet. So practically, from an investor's perspective, this becomes important because he does not want to be in a situation where he signed a term sheet with the founder and the company, and while they're conducting a due diligence on the company, the founder is talking to somebody else to raise funds. So therefore, the period that they keep in these exclusivity arrangements is approximately anywhere between 30 and 60 days. But I would generally advise all startups to keep the duration as less as possible, because you also want the investor to commit to the company and wire in the funds immediately after the due diligence process is over. So the second clause that is generally binding in a term sheet is the clause on governing law and the jurisdiction. What this only means is that if there is any dispute or any issue that might arise between both the parties under the term sheet, since the binding documents are not executed yet, then the parties can decide that what is going to be the applicable law and where is the jurisdiction where this matter will be settled. So the applicable law would generally be India, because the company is based here, and the company is receiving the funds in India as well, from either a domestic entity or from an overseas entity. And the second is, where is the jurisdiction where these disputes will be settled. Now, it could be in any state in India, but generally from my experience, I've seen that there is not a lot of difference between any civil dispute that happens between any state. So generally, I mean, if you're a startup and you're registered, let's say in Mumbai, then you would want to keep it in Mumbai. If you're based in Delhi, you would prefer Delhi. But I think this is something which has to be mutually agreed between the investors and the founders and the company. But from my experience, I think it should be where the company is located. The third clause in a term sheet, which is normally considered to be binding, is the clause on costs and expenses. Well, this only means that any costs that have been incurred by both the parties prior to the signing of this term sheet or at that stage of the term sheet have to be borne by both the parties respectively. So, for example, if you are a company and the founder, if you have engaged a lawyer and you have spent an X amount in paying him for the legal services that he has rendered in order to prepare the term sheet or negotiate it with the investor, then those are costs that you have to bear yourself. Similarly, any cost that has been incurred by the investor at the stage of a term sheet for hiring their own respective lawyer, or if they have conducted any other preliminary, you know, small little due diligence report or anything of that sort, then those expenses have to be incurred by the investor. So this just helps differentiate the fact that neither party is responsible for the costs and expenses of the other. And that is sometimes very important to have, because you don't want to get into a situation where sometimes the investor could could bill you for a certain task that he has done himself, or vice versa. So that's the reason why you have this clause, and therefore it needs to be binding as well.